Good morning, everyone. I'm Amit Lahiri. I'm the Associate Director of the International Institute for Higher Education Research and Capacity Building. And I'm also the Executive Director of the Center for Corporate Excellence and Sustainability. So it gives me great pleasure to invite Professor David Bilchitz to have with us all of you as well, and a warm welcome to this particular public lecture. It gives me particular pleasure to invite David because, he has come here for as a Secretary General of the International Constitutional Law Society meeting, and he has really very kindly agreed to spend the time at our campus and to share his research and to share his scholarship on a very significant and important treaty that has been negotiated in Geneva. It's an intergovernmental treaty on business and human rights. And if it does get enacted, of course, it's going to be a paradigm shift in the kind of binding obligations on corporations. And we live in very troubled times. The International Climate Change Panel has calculated that it's almost impossible to contain the temperature increase, the ocean surface temperature and the Earth's surface temperature within 1.5 degrees. It would possibly be much more than that, with catastrophic effects. One of the agents of economic growth is the corporation, and it's one of the most powerful agents of economic growth. And therefore, the binding treaty on the corporation has very large-scale ramifications. And David will actually speak about his actual experience of not only just the philosophical arguments as to why it's necessary to have such a treaty in place, but also his experiences about the negotiation and about the treaty as such. So with that, I would like to welcome Professor David Bilchitz to begin his presentation, and once again, very warmly welcome him in the midst of all of us faculty and students at the Jindal Global University. So.
There we go. Good morning, everyone, and thank you very much to the warm introduction from Amit Lahiri. I really appreciate also the invitation. We met a short while ago in Berlin and really connected very well, and look forward to many collaborations as well. So I appreciate that very much. Also, Amit was just talking about the Vice Chancellor, Raj Kumar, a couple of years ago, and he had wanted me to come to Jindal, so I'm very glad finally to be here. And also my friend AJ Sanghai, thank you very much as well for a warm invitation. We had you in South Africa recently, and I'm glad to be able to come to India and present here on a topic I think that has relevance to this context. So as Amit Lahiri said, I am working, and I've just come back from Geneva on negotiation around Treaty on Business and Human Rights, but I'm not going to directly engage with the treaty today. I'm going to engage with some issues that connect with it, but we're going to go into a more academic realm today around some work that I'm busy doing and some work that is in process, and I very much invite discussion and engagement because this is an area which has not really been so significantly developed. So I would like to discuss further, and I'll tell you more. But I want to start. Do I have a thing? Okay, let's see. Okay, great. So there's a PowerPoint there. You can. It's a bit weird because I'm on the side and the PowerPoint's that side, so you can look either way. But if you need to look at the slides, or for people who it would be easier for them to read, I have made slides to help you. So I'm going to start off in the occupied Palestinian territories in a venue known as the Tulkarem Industrial Park. And I'm going to tell you about a company called the Keshet Prima Agrochemical Company, which operates there, which produces fertilizer and additives for animal feeds. It is owned by a Mr. Gashuri, a father, and his son. Now, this company essentially has been charged with a range of things, of failing to take into account the health and safety of its workers. It releases polyaromatic dioxins, which are inhaled by the Palestinian residents of Tulkarem, and it also uses dicalcium phosphate in fertilizer production. Now, a report released by Lancet in 2013 said that the residents of Tulkarem have among the highest rates of cancer, asthma, and eye and respiratory health anomalies compared with residents in other districts. There are the highest rates of lung cancer in the West Bank. If you go there, you can see a range of derelict homes on the edge of the district and a range of scorched vegetation. And the area had essentially become uninhabitable around where the corporation was operating, as well as with a range of damaged farmland. That's a picture of a Gashuri agrochemical plant. The factory was originally in Israel, but interestingly, the residents of the area in which it was, which is called Kfar Saba, took legal action, and the company then relocated into the occupied Palestinian territories. Right? So the company essentially was violating Israeli environmental standards, but it relocated into an area of lesser governance, of less strong governance, okay? And there was various reports of the factory being closed when the wind blew in the Israeli direction of the Green Line, and thus it was arguably relocated to the occupied territories precisely so as to get around the Israeli environmental legislation. In international law, Israel has an obligation to protect the rights of the people under its occupation to the highest attainable standard of health and an adequate standard of living for all people in the occupied Palestinian territories. But it seems in this instance it is not fulfilling its obligations. Now, I take this case because I think it highlights a number of legal problems that have become particularly evident in recent years when business has an impact on fundamental rights. I've taken one case. I actually went last year. I was based in Israel for a period, and I went into the occupied territories, and I saw some of these things. So it's based on myself engaging in this context. But this is not the only context. I'm not seeking alone to be particularly political to say this is the worst case in the world. It's not. These cases are occurring all over. Okay? But it highlights a number of these issues. And what are those issues? Okay, well, the first problem is the problem of what we might call corporate human rights obligations. Corporations have a large potential impact on our human rights, but there's a lack of clarity, at least in international law and perhaps constitutional law too, surrounding whether corporations have direct obligations in relation to these rights and the nature and extent of those obligations. So in this context, the question is, has this company, Keshet Prima, done anything wrong where there are no clear domestic legal standards applicable to it, i.e. where it's operating in a potential vacuum? Okay? So that's the question there. What are the obligations that bind the corporation? The second set of problems relates to a problem of what we might call weak state governance. The state is actually sometimes part of the problem, and even though it has a duty to protect against violations, in this case Israel, right, which is paying less attention to those under its occupation. It's also often for developing countries. There might be a range of incentives to attract transnational corporations and an unwillingness to act against them. So the problem here is, what do you do when the state is in fact part of the problem? Okay? That the state, which is the very entity which is supposed to protect people, is not doing so. Okay? The third problem is what we might call the problem of corporate structure. Corporations are designed in law to be regarded as separate legal persons. And this leads to a problem of complex group structures where liability can be avoided. And where corporations actually cross borders, there are claims that corporations in one country cannot be held liable for the actions of a corporation in another because they are different people. You can't hold one person responsible for the obligations of another. Also today, in the way in which our world and global business operates, there are long supply chains with different companies involved, making it difficult to pinpoint responsibility on who is exactly in control. So if you have 10 layers of supply to a particular company, where do you pinpoint the responsibility where there is a violation? And if a small company violates rights, is there any ability to hold a bigger company to account for the small company's violations? Okay? So in this context, the question is, what is the liability of the parent company of Gashuri, of Keshet Prima, registered in the US for the activities of this company in the occupied territories? Okay? That's a hypothetical example. It happens to be a more localized company, but it's an example which is raised in many contexts. Okay? And finally, we have the problem of gaining access to remedies across borders. Okay, what happens when there are violations of fundamental rights? Are individuals entitled to a remedy? Well, they should be, but there are very great difficulties in international law of getting remedies across borders. So there are doctrines such as forum non-conveniens, which deals with whether jurisdiction should be exercised in one country instead of another country, which often is used to block actions. Which law applies? So sometimes, even if you have an action in Brazil or Germany for something that occurs in Bangladesh, if you have to enforce Bangladeshi law, sometimes that law is not particularly helpful to the victims of fundamental rights. There are evidentiary problems in terms of bringing cases across borders, of course. And then if you do eventually get a judgment, which is very rare, there's the difficulty of enforcing those judgments across borders as well. Okay? And many people will note some of these problems from the Bhopal disaster in India, right? Which raised a number of these kinds of issues and has been one of the things that catalyzed some of the discussions in this area. So, our goal must be, if those of us who are concerned with fundamental rights, and all of us should be, I would argue, to address this question and to try and advance the realization of human rights, to address some of these problems and the legal gaps that exist. Many legal experts, as I've said, believe in a need for a binding treaty agreed to between states that address the question of business and human rights. Now, I'm one of these, and I've written a case for a business and human rights treaty, as well as on some features of what that treaty would look like, and myself and Professor Surya Deva released a book last year called Building a Business and Human Rights Treaty, Context and Contours, which examines the possible features of that treaty. So if you're interested in that, you can have a look at it, and if you want to see what the current discussions are, there is a zero draft of that treaty on the website of the Office of the High Commissioner of the United Nations, so you can actually have a look and see what we're busy discussing. But today I'm not going to discuss the treaty debate, though much of what I say is relevant to it and the kind of treaty that will be created. Instead, I'm going to focus on the first problem I mentioned concerning whether corporations have or should have direct human rights obligations in international law, and if so, what the content of these are. Now, I'm not going to address in detail the question of whether they have or should have direct obligations, right, which might seem like the first point in the premise, but it is something that I've discussed before, and the core argument for this is that it is necessary to address the governance gaps illustrated by the Gashuri example. Why? Because if there are no domestic standards applicable, arguably the lack of domestic standards, the lack of domestic any kind of obligations could then allow companies like Keshet Prima to simply avoid any liability. So you need some kind of international standard from which you cannot derogate because of bad current laws in the particular local context. Okay, there are also problems in existing states. The fact that companies often regulate based on what they know about past violations. But with our increasingly sped up technology, there are increasingly new forms of violations which have not already been regulated. So if you assert a general principle of fundamental rights binding corporations, this allows for the development over time of recognizing that those general principles of human rights obligations will in fact cover new forms of violation which are not yet anticipated in regulation, on existing regulation in governments. And then there are a number of particular arguments related to the implications of human rights themselves for particular agents. I'll go into that a little bit, and an argument why, in some senses, the very state-based approach requires a conception of what direct obligations are. I haven't gone through that last argument. We can do that in question time if you're interested in it. But as I said, that's not the focus of my presentation, because the focus is on actually another question, right? Which is, once we accept that corporations have such obligations, what should the content of their obligations be? How should we determine what those obligations are? Okay? And what I'm going to do in this presentation in the first part is I'm going to identify what I term a multifactorial model to determining the obligations of corporations, and I'm going to provide a defense of this. The second part of the presentation, I'm going to elaborate in some detail on 3 of the factors that I talk about, which I think are relevant to determining corporate obligation. And whilst I mentioned briefly others, I might not, because of time, because I want to allow time for questions, I might not get to all 3, but I will engage with at least 2 of them. And lastly, I'm going to seek to discuss the possibility of using the proportionality inquiry in providing a decision procedure for balancing and addressing competing interests in the private sphere and arriving at final obligations. This is relatively radical, by the way, because proportionality is generally used in the context of public balancing in many ways, and so this is an extension into the private sphere. Okay? Ultimately, I'm going to seek to present an understanding of a core decision-making procedure by which corporate obligations can be determined. Okay? So let's go into the multifactorial model. The argument in the Gashuri example, this case, has been rooted in a problem of international law. Yet the question of determining direct obligations of corporations is relatively new in international law. It has, though, been dealt with to a degree in constitutional law in some constitutional systems. So one of the approaches I've decided to adopt is to look and utilize the experience of constitutional law to help provide a model for determining the content of the obligations of corporations at international law. And there, of course, is an interesting argument about the relationship between human rights in constitutional law and international law. I'm going to draw largely from the South African jurisdiction, my own, which has the possibility of direct obligations enshrined in the Constitution itself. And our Section 8.2 of our Constitution reads, "A provision of the Bill of Rights binds a natural or juristic person, if and to the extent that it is applicable, taking into account the nature of the right and the nature of any duty imposed by the right." So in other words, a Bill of Rights or a right can bind a juristic person, but not under all circumstances. There's a question mark as to when and how it does that. Okay? So the case that I want to take that to explain this a little bit is a case called Khumalo versus Holomisa. It dealt with a well-known politician in South Africa who was accused by a newspaper group of being part of a gang of robbers and being under police investigation. The politician argued that this was scandalous, and he sued the newspaper for defamation. The question in court was whether the private law at that time was constitutional, which placed an onus on the newspaper only to publish allegations that were true and in the public benefit. Okay? And the media argued that this was incompatible with freedom of speech because the burden of proving something was true is too great on the media if it wanted to publish something. Okay? And the court said that the case raised the question of whether the right to free speech applied in relation to disputes between private parties. Was it directly, horizontally applicable between them? Okay? In deciding this question, the court outlined a range of factors which were relevant. It firstly outlined what we might call beneficiary-related factors, factors relating to the individual whose rights are affected. Okay? And it said that first we need to understand the intensity of the right. Okay? And this requires an understanding, I'm actually here constructing the court, of the importance of the right within the wider constitutional order. It also requires understanding whether there is an interest in the context that requires protection against invasion by private actors. Is there something that people need that's protected, that needs to be protected against private actors? Okay? The second set of issues it raised were what we might call agent-relative factors. Was there a potential invasion by actors other than the state? And this required considering whether there was a potential impact of a private actor on an interest protected by a right. Okay? And the question is, how far does this extend? Did it have to be only actual impacts or potential impacts? And then the court also said what was important was the nature of the agents in question. And here the court focuses on the role of media in democracy, and in so doing highlights a number of dimensions that are relevant to obligations. The first is the function or role in the community. The media, the court says, plays a crucial role in a democracy in providing a flow of information in engaging people about the political context, etc. And therefore it also grants it a huge amount of power and capacity and the ability to affect a right. Okay? So the nature of the agent is relevant to its obligations, to its ability to affect our fundamental rights. Okay? Once we understand these factors and their normative relevance, the court said it is necessary to establish a balance between the two parties. Okay? On the one hand, you have the right to dignity of the person who has a right not to be defamed for no good reason, versus the right to free speech of the media and the public, of course, to some extent, to learn about things. Okay? And the court, therefore, adopts a new rule in law, which basically says that media does not have a duty to prove the truth of its statements they publish, but they have a duty to have a reasonable justification for believing in the truth thereof. So it has to be reasonable to publish this. And if there is a suit of defamation, the media will then have to justify why it was reasonable to do so. But that reasonableness test is short of proving the truth, because sometimes you can be reasonable to publish something even though it may be false. Okay? So it's not as strict in nature, and the court says this establishes a proper balance between these two rights. Okay? So if we have a look at this case, what is the court actually doing? It has adopted what I term a multifactorial approach. What is a multifactorial approach? A multifactorial approach is an approach in which there's no single criterion to determining a particular issue, in this case, the obligations of corporations. Instead, the determination is a function of multiple consideration. We need to identify features of a situation that are relevant to determining obligations, where none are determinative. Plus, we need a decision procedure. This can result in context-sensitive rules, which, with particular constellation of factors, result in particular obligations. Over time, they may harden into specific understandings of such obligations over time. Now, this is used in South Africa in a range of cases. Okay? One other example, for instance, is evictions law. Given the large number of unlawful occupiers in South Africa on land which is not their own, but it's not their own fault because they lack a place to go, there is often a clash between the right to housing of occupiers and the property of landowners. The court doesn't establish a firm hierarchy in these situations. It rather considers a range of factors to determine whether it is just and equitable to order evictions in particular contexts. So, why would we go for a defense? What would be the case for such a multifactorial approach? Okay? Multifactorial approaches are adopted by courts, I argue, where there is normative complexity. This means that there is no one reason alone which can justifiably determine the obligations in the context where other reasons operating too. Arguably, both morality and law are always faced by normative complexity. As in Khumalo, what we will have is two competing rights which both have normative validity. What is needed is a method of addressing this normative conflict, to find methods to respect both sets of rights. The argument that must be made for multifactorial approaches is that they achieve these goals better than harder rule-based approaches. The latter may fail to be sufficiently sensitive to context, and so land up exacerbating the conflict between competing considerations and leading to unfairness. In a sense, this argument claims that there is an inevitability to exercise a discretion in the contexts of clashing rights. Another argument for the court's approach can also be a certain form of judicial caution. It could well be argued that in complex circumstances, judges may not know in advance the full consequences of laying down firm rules. Whilst it is not difficult to create an exception to the rule against murder for cases of self-defense, it is less clear-cut when it may be the case that evictions should be permitted or refused, particularly in contexts like South Africa with high degrees of inadequate housing and historical injustice. Furthermore, instead of jumping in and fearlessly creating legal rules which may not be optimal, courts outline a range of factors which help it decide without making determinations it may regret. This allows the court to modify its approach and doctrine should these be seen better to address these normative conflicts. A certain flexibility is thus retained for courts to depart from prior holdings in circumstances that warrant it. Such flexibility is particularly defensible in the context of a cutting-edge area of the law, where matters are still unfolding, as in the obligations of private parties in relation to fundamental rights. So if these are some of the cases for such an approach, what can be said against it? Well, clearly there's a high degree of vagueness that characterizes it. Flexibility is brought through obfuscation and unclarity. The court in South Africa thus often lays out factors without specifying how, for instance, they condition obligation. That itself leads to the view that courts will do whatever they wish according to an unrestrained set of vague principles. It could also be argued to be bad for fundamental rights, this kind of approach. Rights are supposed to lay out entitlements that individuals can expect to be realized. If courts and other decisors can simply justify their abrogation on the basis of a vague list of factors, their normative strength of these crucial entitlements is undermined. So what do we do in face of these arguments, both of which have strength? What is needed, in my view, is to provide greater clarity on the details of the multifactorial approach. That requires the following steps. First, there is the need to consider each factor that is identified in more detail. What is the normative relevance of each factor, and in what way does it condition or determine the obligations that flow from it? As a result, a series of presumptions can be attained in this manner. Secondly, there is a need to consider the decision procedure for understanding how overall decisions are made through taking into account all relevant factors. If we can break down the factors and have an understanding of how they are brought together, it is possible to improve clarity and predictability, to restrict discretion, and to retain the normative strength that lies in rights, or at least to some degree, or to the degree that's possible. So, therefore, the first step is, in my view, to start getting in detail into some of these factors, okay, in relation to fundamental rights. Now, as I mentioned to you, there are two sets of factors. One are beneficiary related to the obligations of, to the interests of those who are beneficiaries of rights. And there it's necessary to focus on the interests underlying the right and the impact that private actors such as corporations can have on these interests. So the first step in human rights inquiries must always be to understand what is protected by rights from the point of view of beneficiaries. Okay? Not everything people have an interest in will be protected, but those things that are most important to them will be. And we need to capture what that interest is and its particular impact of the corporation. Right? So just to mention to you interestingly here, and I'm not going to go into this in detail, but corporations may have particular effects on individuals in some sense. So often people's identities are connected to the place in which they work. And if a corporation, for example, fires someone without a due process or intervenes in their lives in some way, it has a particular harsh effect on individual self-esteem, on their own sense of being in the world, right? And that may be different to the impact that might come from an entity which is less close to you in some sense. So we need to take account into the particular relational factors that are affected by the relation between corporations and beneficiaries. I'm going to focus here not on these beneficiary-related factors, which I think are which can be covered in more generally in relation to human rights law, but focus on the agent relative factors, I think, which perhaps affect in some ways more the difference between corporate obligations and other forms of actors. Okay? And so trying to understand what corporate obligations are vis-a-vis other actors like the state, for example. And I'm going to look at three factors: capacity, function, and autonomy. Okay? And as I say, we're not going to do too much on function. I'll just mention it to you. So capacity is a very common argument, right? And the argument, I'm giving you a quote from Justine Nolan. She says the following: the influence of transnational corporations on the economic and political life of most countries and on economic and political relations in general has increased greatly in recent decades. Today, the economic capacities of transnational corporations go far beyond the economic capacities of the countries in which they operate, and their political muscle is often far greater than the ability of states to regulate them effectively. this power should be accompanied by responsibility. Okay? So there's a relationship between power, responsibility, your capacity to harm rights, and the obligations that you have. Okay? So the argument is X has a right, Y has the capacity to affect the right, therefore Y has an obligation to exercise that capacity. Now there is an interesting philosophical argument why capacity translates into obligation, okay, which is itself something we can debate, okay, but interesting question here is, is this argument valid on its own terms? And how far does the responsibility extend? I'm going to split this discussion into negative obligations, obligations to avoid harm, and obligations positively to contribute towards rights. Now, the capacity to harm alone translates into an obligation not to harm, right? That's the argument, right? If you have an ability to harm, you have an obligation not to harm. While this formula appears attractive and seemingly easy to apply, it is not adequate. Certain dimensions are hidden by the seeming simplicity of this formula, which should not be conflated. Okay? A capacity to harm can mean a capacity to have an impact on a right. So let's think about newspapers. Newspapers can impact on someone's reputation and dignity. They probably do every day do that. Does that automatically mean they cannot publish anything that violates dignity or reputation, let's say, right? We don't think so generally, right? We think newspapers can publish. There's circumstances in which it's justifiable to impact on reputation and circumstances when it's not. And so we need to distinguish between negative impact in relation to rights and impermissible impact, okay, when it's not permissible, right? Not every negative impact is impermissible, okay? So this is something that most of you will be familiar with from the state itself. The state can sometimes have infringe a right, but we see it's justifiable to infringe the right, okay? So the capacity to have a negative impact, it is probably a necessary condition to have an obligation. Without any capacity to have a negative impact, it's not clear why you would have an obligation. But it's not as sufficient, it's not enough to have an obligation. So we need to consider other factors in determining whether something's impermissible or not. Okay? Secondly, positive obligations, right? The capacity to impact, right? Arguably, Amit mentioned in the beginning that corporations are an engine for economic growth. They can have positive effects on society. Does a corporation therefore have an obligation to do everything it's able to do to influence fundamental rights, right? So GlaxoSmithKline has a higher market capitalization than the GDP of Malawi in which it operates. Does it have a duty to provide every Malawian citizen with health care? If it has some obligations, what are the limits of its capacity? And then there's even a harder question which arises in the context of positive obligation. Google has 2 times the market capitalization of Glaxo. Does Google, I mean, these figures I'm playing with, okay? I'm not giving you exact figures, but I'm saying these might be true, but whatever. That's not important. It's about the concept. Does it have the same duty if it has 2 times the market capitalization? Does it have 2 times the amount of duties? Google does not operate in the healthcare sector. Is that relevant to what it must or mustn't do, right? Is the duty shared? And if the duties are shared, according to which principles? Okay? The state is also involved in healthcare provision. If the state is involved in healthcare provision, does this remove the duty of corporations? Though we know that corporations affect the ability of the state to provide by the prices, for example, they set for expensive medication or various treatments. Okay? So these are some things just to show you that there's a complex translation from capacity to obligation, right? Some might argue that corporations don't have any positive obligations. I disagree with that view. I think they have an obligation to impact positively on society, and in India you have in fact adopted law to that effect, right? To require 2% of corporations' profits or whatever to go into CSR. So you've actually had you see corporations as having an obligation to society in a positive way. Okay, you've quantified it, but where does that 2% come from, right? How do we decide on what the extent and nature of those obligations are? Okay, so this raises that kind of question. Okay, so corporations in summary, in relation to these factors, I hope I've illustrated the complexity, may have variable capacities to affect fundamental rights, and so that in itself will impact on the obligations that they in fact have. They may have an ability to impact negatively and a capacity to impact positively. His points initially suggest some obligations on corporations, but they do not provide us with an understanding of the limits of such obligations, nor their allocation amongst corporations. Capacity, importantly, requires an investigation of what exactly corporation can do in this area. It requires an understanding of whether it has special abilities as well in any way. A clear-headed understanding of what a corporation can and cannot do provides us with a starting point for determining obligations. Yet that is not sufficient. So I turn now to a further criterion which considers their role or function in society. As we saw, Khumalo referred to the function of the media in a democratic society. Now, of course, this is not a simple issue. What is a function, right? That needs ultimately determination in relation to the ends or the purposes of an entity. And we need to construct the function in light of the reasons for the creation of the entity, its activities, and the perspective from which this question is asked. So the media, for example, has a role in disseminating information and is a platform for the expression of opinion. For private parties, it might be a means to make money. In dealing with this, we have to consider all those obligations. Now, obligations can flow from function together with the capacity to affect the interests of individuals that are protected by rights. The media may not deliberately peddle false information that would harm the interests of individuals to receive accurate information, which is part of its function. The media may also have a positive duty to provide a platform for diverse opinions, because that's part of its function to enable individuals to express themselves. The role of a social body can thus grant it the capacity to affect individuals in ways that matter to them. And it is this that, together with an understanding of their interests, generates obligations. Now, a lot of this discussion often is framed around whether the role of an entity is public or private in nature. And an interesting case in this regard in South Africa was a case called Allpay, which dealt with a company which was contracted by the government to provide social grants by the state. So I don't know what the situation is in India. I know you have a range of also social provisioning. But in South Africa, if you have a child, you're entitled to a certain amount of money per month. If you are disabled, you're entitled to a certain amount of money per month from the state. If you are an elderly person, you're entitled to a certain pension from the state. These are called social grants, okay? And those social grants are paid once a month, and the state did not have the ability to do it on an efficient level, so it outsourced it to a private company, okay? The problem was that the contract underlying that, the tender process, was filled with irregularities, and the court declared the contract illegal, okay? The contract by which it was provided illegal. The problem was that if the company stopped providing those things, millions of people would lack the ability to continue with their lives, to have the basic means of existence, right? So the problem in law was, you take away the contractual relationship between the state and the private company, right? You need the private company still to continue. What is the basis for the obligation of the private company to continue, right? Providing those goods and services, okay? The court said that the company, by being prepared to engage in this relationship, had taken on a fundamentally public function. The public function meant it had, for those purposes, become part of the state. Essentially, this company had, for the purposes of what it was doing, become an organ of state. And as such, it had the obligation to continue providing these services, even though there was no contract, okay? Because it had adopted essentially a public function. The public function the court conceptualized as a power emerging from a constitutional right, a power emerging from a statute, and emerging from a situation where the individual rights can be seriously affected. The implications of being public means that one cannot just, the public nature of a role affects and reduces one's private autonomy. It means that, for example, one cannot simply walk away from a contract. One must be accountable publicly, though the court in this case also said the company wouldn't be forced to make a loss. It was still, to some extent, a private entity. Okay? Another case, which I won't go into, the AMCU case, dealt with the power of mines to extend agreements made by a majority union to minority union members. And here the court considered the market dominance of mines and the relationships of coercion and subordination that are created. This is, by the way, a very strong feature of the jurisprudence of the Colombian Constitutional Court when considering private actors, is these questions of subordination and power. Okay? Large corporations can have an impact on the interests of third parties who have no say in their governance. Traditionally, fundamental rights are there to protect individuals against the overweening power of the state. The argument is that the same rationale applies when there's strong asymmetrical forms of power with private bodies. Okay? So, essentially, to quote the Constitutional Court of South Africa, there's no impenetrable wall between the public and the private. The source of power of any corporation lies in legislation, which enables it to exist. This is not enough to make them wholly public, but it does suggest that there is a public dimension to any corporation. Legislation was passed for a social reason. Of course, the corporate structure is meant to have social benefits, even on its capitalist interpretation. It's meant to create growth. It's meant to encourage new innovations through enabling individuals to take risks and accumulate capital because they are not necessarily going to be subject to liability for the full extent of the liabilities of the corporation. Every small corporation then can have, even a small corporation can have a public dimension to them, and this may affect their obligations. If you function in a particular area, there's an interesting question. Do you have larger obligations? I raised this before. So if you're a manufacturer of pharmaceutical companies, right, in South Africa we have a terrible situation. I know India's tried to resist this issue of intellectual property and around healthcare, which I think is very good. But we have a situation where a manufacturer, for example, charges for a very effective drug in preventing breast cancer called Herceptin, thousands of dollars per month per person, which essentially makes the drug out of reach of most people, and even the state cannot afford to provide it. So essentially you have a situation where women are dying today in South Africa because they cannot access a drug which can treat them, right? Do manufacturers of pharmaceuticals, for example, have a larger duty to enable those kinds of drugs to be made public? What about book publishers, right, which affects us all in contexts where there's significant poverty, okay? My country as well, I see this with students. We often charging of books. Books are quite expensive. People can't gain access to material. Do they have duties in developing countries, at least, to make the material more available, to realize the right to education at either cheaper rates or perhaps not even charge for certain aspects, okay? So the analysis suggests that where there is an impact on constitutional rights and the power to affect others that emerges from a social role, there are good reasons for imposing obligations. Okay, I'm not going to discuss the relationship between function and capacity, which is an interesting conceptual issue, but go on to the third criterion here, which relates to autonomy. Okay? And autonomy is the third criterion, which I think we need to grapple with, and it draws in a kind of conflicting dimension here. And autonomy, as I refer to it, those of you with a philosophical training will know it's a complex idea. Here I refer to it as involving two dimensions. What I call the dimension of integrity, which involves recognizing the worth and not to be treated as simply a means to someone else's ends, and freedom, being able to choose and determine one's life according to one's own rational agency, one's own thinking. Okay? And when you're determining the obligations of an entity in the private sector, it seems that we must take account of the fact that individuals have autonomy. Autonomy, though, is not absolute by virtue of living in society, right? We don't have a right to make decisions to take someone else's property or to kill them or something like that. Okay? Now, autonomy interest, importantly, is most strong in relation to individuals who have dignity. I would argue the state, in fact, lacks an interest in autonomy. The state may have an interest in protecting individual autonomy, because that's one of the things it's meant to be set up to do, but it itself has no autonomy interest. Okay? And there's a continuum in between. The more state-like, the less importance is given to autonomy. The more like individuals, the greater the importance given to autonomy. How does this apply to corporations? Well, it requires us to think about what is the nature of a corporation. A corporation is non-reducible to individuals underlying it, but dependent upon them, right? So a fundamental dimension of the corporation, as I've talked about, is a separate legal personality. It is a separate person, and it has perpetual succession. It continues irrespective of changes in its ownership structure. Okay? These are ideas which are conferred by society for reasons to benefit society. Okay? Because the structure has been proved useful in encouraging innovation and growth. Okay? It is also a vehicle for individuals to utilize with their own economic projects. Okay? Autonomy interests, thus, I would argue in relation to a corporation, are not as pronounced as in the case of individuals, but not absent given their connection to individuals. Okay? So, we need to grapple with the full complexity of these issues. We have outlined 3 agent relative factors that help determine obligations. Now, the problem is some of these potentially pull in different directions. The capacity of an agent to affect a beneficiary's interest may push in favor of imposing an onerous obligation. If an autonomy interest applies, then that may counsel against imposing that obligation. How are we to make a final determination of which obligation an agent has? This needs to be done through a rational decision-making process. And the final section of this presentation seeks to suggest that the proportionality inquiry may provide guidance in how to make decisions in these conflicting cases. So ultimately, determining obligations of a corporation involves a balancing of interest. What process of reasoning should guide such balancing? Consider here whether the traditional approach used in relation to the state has a role to play in this regard, namely proportionality, right? And I don't want to go into this in detail. I think many of you will be familiar with this, okay? But proportionality essentially involves a 2-stage inquiry. The first stage involves understanding the rights and the interests affected and whether prima facie a right has been infringed. The second stage involves questioning whether there's a justification for the infringement, and that's where the main proportionality test is given, right? Your court, by the way, has outlined this in the Ardar judgment recently. Okay, I actually was quoted in this particular engagement of the necessity test, which itself is very interesting in relation to how you lay out the test. But basically, it has 4 components. The first is, what is the purpose for the measure that infringes a right? Okay? And then one has to work out, is there a relationship between the means adopted and the purpose? Right? That we might call the suitability inquiry. Okay? Is there an alternative that sufficiently achieves the purpose but has a lesser impact on the right? This is the necessity test, right? And then are there benefits that are proportional to the harms? Are the benefits of the measure of the infringement proportional? Do they not too severely affect the right in question? Okay? And this is the broad proportionality test. So can this be applied to corporations? Right? I would argue yes. Corporation, let's think about a corporation that passes a policy that no individual employed by it may tweet anything in their personal capacity. Okay? They had a disaster, let's say, someone in their corporation tweeted something against Xi Jinping's recent crackdown, which led to, or perhaps we might think of the Saudi case now, criticizing the Saudi Arabia, and suddenly Saudi Arabia and China doesn't want to invest or doesn't want to have anything to do with the corporation, right? So they've decided to adopt a strong policy. No employee may tweet anything in their personal capacity, and you can extend this to write an opinion piece in your personal capacity. How do we think about this? Well, the first stage, we need to consider the interests and potential impact on the interests of the individuals. If violated, there's a prima facie infringement and obligation. Okay? So here we need to think of what would the impact be on a free speech of an employee? What's the power of the corporation in this regard on the employee? I would argue there's a very severe infringement on the rights of someone to actually have a political opinion, to express their opinion if you're employed by a corporation in this way that you cannot actually give expression to your own views and your political views. Okay? The second stage is, well, is there a legitimate purpose? And interestingly here, the legitimate purpose depends on the agent. Okay? So the state may have no particular interest and no right to stop you, in this case, from expressing your views. Okay? The state doesn't have an interest in its reputation or something. Corporation may have a legitimate business interest, right? Its protection of its reputation is legitimate, okay? It has an interest in goodwill, it has an interest in developing its business, and those business interests may be a legitimate purpose, okay, for the corporation in this area. Then we need to test the further parts of the test. Is the measure well designed to realize the purpose? Does the widespread restriction on people's free speech in the public sphere, like through Twitter, advance the purposes of the firm? Well, in some ways it clearly does, okay? It prevents an employee from going on a mission of their own, okay? On the other hand, it could make it a less attractive place for people to come, right? People might say, oh, I don't want to be employed by this particular corporation, okay, Coca-Cola or whatever it is, okay, because if I go there, I can't say anything, right? So that might affect and harm the firm as well. So that inquiry is actually quite interesting because it raises questions about how do we capture the rationality of the firm itself, okay? Secondly, we might ask, is there a less restrictive measure that could be adopted that still achieves the purpose of the firm? Well, we could imagine that this is a very draconian policy, right, in some sense, right? And perhaps it would be possible to achieve the views of the firm by having a restriction on employees, for example, writing anything on the company's Twitter account or the company's website, or potentially also having a clear disclaimer that this company respects the free speech of its employees. It takes no responsibility for what employees say in their personal lives. However, the company itself, employees may not represent the company in ways representing their personal interests, right? We can imagine that would be a less restrictive measure, which would help the company mitigate its losses, okay? It may not achieve the purpose fully, so if the CEO came out against Saudi might still take measures, so you might say, well, it was necessary for the company. We could then go into the last stage of test and say, is it proportional? Is it not necessary? Isn't it too severe an impact on people's free speech to restrict them from saying anything in their personal capacities for the company's interests? And I would argue that such an alternative measure would be something which would realize, it would still restrict free speech to an extent, it would realize the company's interests, but have a lesser impact on the rights, okay? So this, I would argue, helps capture corporate obligations in relation to rights. The nature and extent of their obligations depends on the agent, their role in society, the connection between means and ends, and an overall evaluation of benefits and harms. This provides a framework which takes account of beneficiary-orientated factors and agent-relative ones without conflating them. And it allows for the determination of obligations incrementally without having to have a once-and-for-all specification thereof. That would allow, for example, an expert committee and domestic courts to help develop our understanding of corporate obligations in this regard over time, but provides a clear analytical framework for attempting to balance. So let us return to Keshet Prima in the conclusion. As we saw, Israel was part of the problem and there was no capacity to hold Geshuri account in this area. Geshuri shows total disregard for people's environment, life, and livelihoods. Surely this should have legal consequences. What then are, or how could we capture corporate obligations? Well, Geshuri should be held to account for their human rights impact. Which impacts? Firstly, we need to consider prima facie the harms that have been caused to people's interests. Okay, and in this case, I would say it would be the health and environmental rights which protect that. Okay? What is the capacity of Geshuri? It is an agrochemical company which clearly has a major capacity to affect individuals' basic interests. What is its function? Well, it is a corporation and includes as part of its role ensuring that there are social benefits to the community. It is an Israeli company operating in an occupation zone and so holds disproportionate power in relation to those around it. Okay, so this allows us to take account of that kind of important nuance of where there's disproportionate power effects. And so there would be here good reasons, I would argue, for prima facie obligations on Geshuri to address the human rights impact of its activities. What about its autonomy? Geshuri is not a state party. It seeks to operate for profit and to achieve the greatest profit. Is there a justification that could stand up to the proportionality test? Okay? Well, we need to then consider if that is the case. What are the purposes of Geshuri? Well, we can say here its aim is to operate and to make profit. What about the rationality or suitability? Let's assume it is part of our operating plant to pollute. At the same time, its operations may harm its relationship with the community around it, which may affect the long-term capacity to operate. So there may be a degree of irrationality in its operations as well in the longer term. What about the necessity? Are cleaner methods of operating possible? Could it adopt precautions about when it operates? For example, if the wind is blowing, it shouldn't actually be operating the plant in certain directions, okay, or in all directions. Proportionality. Are the harms to the individual severe? Yes. The autonomy interest of Gashuri is not that strong here, right? Its autonomy interest, it needs to be considered against in relation to the harms. There's a situation of high-level asymmetrical power. There's a large vulnerability of individuals into Karim, and it's affecting a public good, namely the air. I would argue that all these factors together lead us to a conclusion that could not justify allowing Gashuri to continue to operate without ensuring the safety of the plant to workers and those who live around it. So non-state power has grown and is increasing. We have always regulated private power, but there are good reasons to think about how fundamental rights would apply to these bodies. I've suggested a multifactorial model which takes account of agent, relative, and beneficiary-orientated factors, and finally results in a balanced inquiry. This can be used by courts, but also, I would argue, internally in businesses to help determine their own obligations. Providing such an understanding seems to me to be important in ending impunity for business that still occurs in many contexts, and to correct for an imbalance in the global legal system that has essentially prioritized profits over people. And so I think and hope that in this way, in thinking about these questions, we can help create a more humane future in the 21st century. Thank you very much.